Hey, everybody, and welcome back. This is Graham Friedman here with another episode of the Graham and Brian Show. Coming to you with a really interesting conversation around the intersection of the legal sector and everything going on in crypto, specifically talking NFTs this time around. Now, as many people know, Republic is a platform where issuers can sell either equity or some sort of securitized version of what their offering is to buyers. However, behind closed doors, we also like to think of ourselves as legal engineers, really looking to explore the spaces, especially in the cryptocurrency landscape or the Web3 world, around what's going on with regulation and enforcement and how we see the world moving forward. As many people know from using our product, Republic focuses largely on securities issuance and the digital sphere, really where those two worlds come together. For many people, they think of us first and foremost as a product offering in that vein. But behind closed doors and sort of in a personal realm, we largely view ourselves as legal engineers, reviewing how things work presently, how we see the technology shifts happening throughout society, and how those really do interact with regulation and laws, especially here in the United States. And for that reason, we were very excited to get the opportunity to speak about this upcoming case around NFTs, regulation, and what is becoming a suit against the SEC for clarity. And in that endeavor, we are joined by Brian L. Frye, one of two plaintiffs, who is teamed up with Jonathan Mann, aka Song a Day Guy, a fine gentleman who has been writing a song a day, often about a variety of topics, sometimes about regulation and SECs, enforcement viewpoints. And he has been selling those on the Ethereum blockchain in the form of an NFT for ETH for many years now. The problem being that recently a project that did raise capital around NFTs and through that methodology, that Web3 format, had a action letter coming against them saying that these were illegal securities offerings. The project that I am referring to is called Stoner Cats. It had very famous people attached to it, such as Ashton Kutcher, Mila Kunis, Seth Green, a variety of others. This was an entire television show that basically bootstrapped its model through the NFT fundraising process. And it was pretty exciting to see this happen, right? Users were able to invest in these NFTs, which would fund a television show, have all sorts of opportunity to contribute to the storyline, et cetera, et cetera. However, this project was pretty much ground to a halt via onerous legal actions, SEC regulatory complaints, so on and so forth. So this is something that we are, as an industry, trying to figure out what is the path forward. If the SEC is going to tell us to please come in and register, how can we do that without basically committing suicide in the form of a business? Because what we have seen is that people that have gone forth through this methodology have encountered many legal hurdles, whether it just be costs and fees, regulatory gray zones, a variety of opaque regulations. So in that endeavor, we are joined by one of the plaintiffs, again, Brian L. Frye, who is an interesting individual, actually has a Bachelor of Arts in Cinema Studies from the University of California, all the way to a Master's of Fine Arts in Filmmaking from the San Francisco Art Institute, evolving over time to get his Juris Doctor from NYU School of Law. Go Violets, I am also NYU. And we are also joined by Republic's own General Counsel, Mario Lattuga, or one of the minds aforementioned in this legal engineering feat that we really do pursue. So we do hope to take the next hour or so of conversation to dive a little bit more deeply into what Brian is doing alongside Jonathan Mann, Mr. Song a Day, how they are pursuing clarity from the SEC and their methodology to take this public in a format that hopefully provides some answers and clarity for the rest of the industry to move forward on. With that being said, let me begin the interview, and thank you so much for tuning in and learning alongside us here at Republic.
Super excited to be here. Mario Lattuga, Deputy General Counsel and Head of Global Legal here at Republic, former securities litigator, adjunct at Georgetown Law, and basically just really obsessed with the interplay between digital assets, securities laws, and just generally the industry at large. So super pumped to have a conversation again with Brian. We spoke recently. Really just love his work and love in how he thinks about these issues, and it's on everybody's mind. especially recently with a lot of enforcement actions coming out. So super pumped to chat today and kind of explore the nuances with also not going too in depth on some of these securities things and geek out. Although maybe we will, we'll see.
Excellent. And Brian, I'm gonna toss it to you. Let's get a little introduction.
Great. So I'm Brian L. Frye, and I like to refer to myself as the Dogecoin Professor of Law and Grifting at the University of Kentucky, J. David Rosenberg College of Law. That's not my actual title, but I'm manifesting. You got to claim the title you want that you think you deserve, and I think that would be appropriate for me.
I,
And, I wear a bunch of other hats too, which we can talk about.
Excellent. So, without further ado, the topic of this conversation is largely about, the overarching term that I think we hear a lot from the powers that be, which is come in and register. We are going to unpack that throughout this entire conversation, but would very much like to get your take on why that is so difficult, and then a little bit more as to what that leads into with what you're doing around NFTs, especially the song a day and your no action request letter.
Yeah, so I mean, I have firsthand experience with trying to come in register. In fact, this kind of started in 2019 when I sent the first two no action letter requests to the SEC, proposing to sell a work of conceptual art titled SEC No Action Letter Request, which consisted of sending a no action letter request to the SEC, explaining why what I was doing satisfied all the criteria of the so-called Howey test promulgated by the Supreme Court for kind of providing the broadest definition of what constitutes a security under the securities law, and therefore something by the SEC, and therefore why the SEC should tell me that I wasn't allowed to sell the work of conceptual art that I described in the book that I was proposing to sell it, because doing so would constitute an unregulated security. So I mean, a friend of mine joked that it was actually the first that he was aware of SEC action letter request. Essentially, I was telling the SEC, here's what I'm proposing to do, and I really think you ought to tell me I'm not allowed to do this. They instead made the administrative decision not to respond to me at all, right? So I sent the no action letter request. They ignored the no action letter request, or at least they didn't respond to me in any formal way to the no action letter request. And then I sent a second one a couple of years later as the NFT market blew up, proposing to, in effect, do the same thing, but make it an NFT instead of making it a more traditional work of conceptual art sold via certificate. And once again, the SEC declined to respond to my no action letter request. Although in that second no action letter request, I referenced the previous one, explained to the SEC that this project was identical to the previous project. The only difference was that I was selling NFTs rather than selling paper certificates. And therefore, I was still of the opinion that what I was doing was selling an unregistered security. But because the SEC had declined to respond to my previous no action letter request, I was going to take that as tacit acknowledgement that they did not believe that what I was doing was selling an unregistered security, and therefore I would go ahead and do it without their permission.
See, now I love the take of calling it an action letter request. I think this is a really interesting reframing of the whole idea, because a no action kind of concept is really what we're getting right now, and it's what we're trying to avoid. So it's kind of an ironic thing to push out there and move in that direction. But as with all great stories, I think that's what we're getting to. But let's take it back a little bit and kind of set the tone with a little bit of your origin story, if you would, because you did mention to me that you actually do come from the background of art, so you have a little bit of that artist in you, which I think it comes through and it shines, and then that also matures into your legal background. I would love to just hear a little bit more about that.
Yeah. So, I mean, I would say this entire story kind of culminating with the lawsuit that Jonathan and Mann and I recently filed against the SEC in federal court right here in my hometown, current hometown of New Orleans, Louisiana, really began, I would say, way back in 2009, 2010, when I was a junior securities lawyer working on Wall Street at Sullivan and Cromwell, big, international law firm, represents small clients like Goldman Sachs, among others. And a lot of the work I was doing as a litigator there was securities related work, unsurprisingly. And a lot of it was kind of more theoretical background type stuff, writing memos and answering questions, legal questions from partners and so on. One of the things I was thinking about was the definition of a security under Howey. And like many securities before going to law school, I went to law school and had a career, as it were, as an artist, including being included in the 2002 biennial with a couple of motion picture films that I made.
Amazing.
16 millimeter film. So I was very familiar with the art world. I had, interned at MoMA and at the Whitney, and knew a lot of conceptual artists, was familiar with the kind of art market, how it worked, and written pretty both journalistically and theoretically about art and the art market. And what struck me as a securities lawyer was that if you just squinted a little bit, conceptual art looked an awful lot like a security, right? So normally when you buy and sell art, we conceptualize it as, buying and selling objects, specifically authentic, right? So an artwork is valuable because it is connected to the artist and represents an authentic expression of the artist's intent. But conceptual art is different, right? So this is a kind of an art form that was nominally conceived or really coined, as it were, by Sol LeWitt in the 60s-ish, right? But I would trace it back really more to Marcel Duchamp and other Dadaist and surrealist artists from earlier in the 20th century. And essentially, it's a form of art practice where the idea is what matters and the execution of the idea is really not that important. So it's really not so much about the object. In some cases, there really is no object. Sometimes really by intent, there's no object. It's about the concept behind the art project. And, initially it was like, well, this sort of violates the norms of the art market, right? Because without an object to buy and sell, what is the art market going to transact in? But as always, capitalism will out. The art market, while it's about art, it's still a market, and markets always find a way to transact in things if they want to do a transaction. So the conceptual art market effectively became a market in certificates, right? Certificates of authenticity. Normally, you'd have a certificate of authenticity attached to an artwork, right? So attached to a painting, attached to a sculpture. In the case of conceptual art, it was a certificate attached to nothing, right? You're just transacting in the certificate itself. So what happens when you do a conceptual art, right? Well, the artist comes up with an idea and then generates a certain number of certificates, as many or as few as they choose, each of which represents an edition of the artwork in question. And then they sell the artwork to collectors by selling them the certificates. And, as a securities lawyer, former artist, I looked at this and was like, well, how is that any different from selling a stock certificate, right? I mean, you've got something that people think is valuable and you're parceling it off and selling it to them in shares using a certificate. I mean, that's how is that not a transaction in an unregistered security? The problem was that, as a junior lawyer, kind of budding academic, I was like, well, how do I articulate this in a way that makes sense to people so that they understand it, right? Because when I talked about this to my colleagues at the law firm, these white shoe lawyer, senior partner types, they looked at me like, what the hell are you talking about? Like, who would buy something that stupid, right? And when I talked about it to lawyers, they were like, securities, what do you mean? I don't understand. How is it's art? It's not markets, it's something different, right? It was very hard for me to kind of figure out how to frame the observation in a way that would make sense to people. I struggled with it for a really long time. And it didn't hit me till, a decade later, right? That the way to do it was to do what I like to call activating it, right? So to take the idea and rather than explain the idea, to show the idea, right? And that's why I transformed it in the way that I did, right? So what I did, I wrote this, I did the SEC no action letter request artwork, right? But it was accompanied by, or really more or less constituted by, a law review article, which I like to describe as a prospectus for the sale of the work of conceptual art in question, right? Paired with this an actual no action letter that I sent, which kind of made the artwork happen, as it were. And I think I like to think that that really worked, and it changed the way I thought about doing legal scholarship as well, because I realized there were lots of ways to activate legal scholarship in that fashion, right? To use it as a medium for conceptual art rather than just as a kind of transparent way or neutral way of explaining or expressing ideas, right? To make the scholarship itself the vessel for the artwork, as it were, right? So that's what kind of got me started on that front. And, and the paper was initially pretty successful. I put it up on SSRN at the end of 2019 as a scholarly, like a database for scholarly preprints where you can just upload whatever you want to. People saw it and thought it was funny, and some people alerted Matt Levine to it, and he ended up writing about it a couple of times in his Money Stuff column, which obviously got it a lot more attention. And the consistent response to the paper was, well, of course, Matt Levine was famous even then and now for saying everything's a security. And then he's like, well, wow, everything, but maybe not that. I'm not sure what's going on here. This doesn't make sense. That can't be right. And the consistent response from a lot of people, both in the financial world, in the securities world, and in the art world was, well, that's not really a security what you're doing, because no one would actually buy that thing. It's just a joke. You're not serious. There isn't really a market for it. I was like, that's a really lame objection, right? I mean, it's no defense to the SEC to say I was proposing to grift people with a security so lame that no one would buy it, right? That's not a defense that's going to get you very far in court or before the SEC. I mean, I was like, that just doesn't, there has to be a more substantive reason than that. There has to be a more meaningful rationale for why what I'm doing doesn't qualify as the sale of an unregistered security. And I was really disappointed that the SEC refused to engage with the observation that I was making. And in fact, I filed a FOIA request, which they refused to respond to on administrative deliberation grounds. But then a friend of mine, a law student at the time, filed a second FOIA request. And actually, I learned later what happened was somebody at the SEC fucked up. Can I swear?
I'm for it.
We're in it.
Somebody at the SEC fucked up and didn't respond in a timely fashion to the FOIA request. They missed the deadline for putting in a administrative deliberation objection. So then the SEC was obligated to respond to this person's FOIA request. And so they did, but they responded by simply sending him everything that I had sent to them with everything else redacted, like literally everything else redacted, except like 2 sentences from one email where they referred to my article as fanciful, which I found really amusing at the time, right? So I mean, like, I kind of let that sit and percolate for a while. But then a couple of years later, when the NFT market blew up, I was like, well, gee, the objection to this was that this isn't really a security because no one would buy something like that. Well, there's plenty of people out there buying stuff like that now. And I like to describe the NFT market as like, I felt like I'd fallen asleep and dreamed of a beautiful market and nothing. And then I woke up and it existed. Right? And I was like, this is so amazing. So I just recreated the same thing and sold this artwork in an edition of 50 in like 20 minutes to a bunch of people who were like, wow, this is really funny and interesting and a great troll on the SEC. And that's sort of what brought me to the attention of Jonathan Mann and Jason Gottlieb, our lawyer, and made me kind of a good addition to the lawsuit that we brought.
Can I just ask one quick question as the non-lawyer in the group? Can you just unpack the FOIA requests and what they are?
Oh, sure. So the Freedom of Information Act, or FOIA, is a mechanism by which people can get information from the government. Essentially, FOIA obligates the government to provide factual information in the form of documents to people who request it. But there are certain exceptions to what the government does or doesn't have to provide. Normally, they're required to provide anything responsive so long it isn't confidential or top secret or something along those lines. But there is an additional limitation that agencies often assert called the administrative deliberative privilege. And it's kind of like a version of what attorneys would refer to as work product, right? Essentially what it's saying is you're not entitled to know what the agency lawyers were thinking about things. You're only entitled to factual information that was provided to or generated by the agency. So it's like a very limited form of like privilege-ish for agencies. A lot of people, myself included, think that agencies have a marked tendency to abuse the administrative privilege doctrine, but there you have it.
Brian, I'll also say, I think it's very interesting kind of the response that you got with respect to why what you were doing was not a security. And I think it's really interesting when we think about Howey, because to our prior conversation, like you could kind of fit a lot of things within that bucket, which ties into this, fifth factor of like, is this the type of thing the SEC wants to regulate, right? And then which makes you actually take one step back and you say, wow, like that's actually really problematic from a certain perspective. If like they decide that I want to regulate this and then they find a way to regulate it within the bounds that they have, that's a little scary, right? And might kind of give pause to industry participants, because how do you know what you're doing is a security or is not a security, is a commodity, is not a commodity, is it a commodity? Like, because you still have, certain ETFs coming out. So I'm curious your perspective on how you look at that fifth prong that some say of Howey, and how you think like people may operate within the current regime that's out there today. And I know we're probably going to hit on some of these points, so maybe just focus on that fifth element.
Yeah. So I mean, this was a big point of the paper that I wrote and sent to the SEC as my prospectus, being, I think, critical, but justifiably critical, of the SEC's willingness to really think long and hard about its regulatory mandate, right? So the Howey test, essentially generated by the Supreme Court way back in the 1940s, right? This is almost 90 plus years ago, right? The Howey test says that an investment contract, the kind of broadest term for security, is defined by the Supreme Court as an investment of money in a common enterprise with the expectation of profit from the efforts of someone. So the four factors, right? Investing money in a common enterprise, expectation of profit, efforts of others. And as you say, Mario, that's an incredibly broad definition, because if you describe it in the right way, you can fit almost any investment, almost any transaction can fit into that definition, so long as you decide how to define it in such a way that it satisfies those criteria. And that's literally what I was doing in this paper, saying, right, I'm going to redescribe making a conceptual artwork in Howey terms, right? And more than that, kind of give the project I'm proposing criteria that make it especially securities-like, right? So I added a bunch of additional criteria to sort of amplify the securities-likeness of the project I was like. I said, like, well, I'm going to get other law professors to act as my agents to market the conceptual artwork for me, and I'm going to—
Brian, just to one sec, your goal was to have them say this is a security. Like that was the goal.
Well, my goal was to embarrass them. My goal was to troll the SEC. I mean, that was the goal of the project in question, to say to the SEC, you can't respond to this because you don't have an answer to the observations that I'm making, right? And so, one of the things that I observed, as you say, Mario, in the paper was, my friend Ben Edwards, who's also a securities law professor. He is a securities law professor. I actually mostly teach intellectual property related subjects, among other things. But Ben Edwards, he's a securities law professor and business law professor at UNLV in Las Vegas. And he observed to me, right, as we were talking about these questions, like, well, look, there's really this kind of fifth shadow factor, as he described it, and does it look like a security, right? I mean, the SEC has discretion whether to regulate or not to regulate. So the four-factor test is kind of beside the point, because at the end of the day, what really matters is, does the SEC want to regulate this thing in the first place? I was amused to find that Hester Pierce, the SEC commissioner, actually picked up on this fifth factor language that I used in the paper, and actually quoted me in one of her speeches at one point, which was pretty exciting and cool to be recognized.
Big moment.
Yeah, big moment for me.
Crypto mom.
But for me, this is really a critical observation because of how the SEC operates, right? I mean, it's almost exclusively regulation by enforcement rather than regulation by rulemaking, which is really different from the way most other agencies regulate. The typical mode for an agency is to promulgate general rules for the industry or for the area of the economy or activity that it's regulating, and tell people what they're allowed to do and what they're not allowed to do. And the SEC, by contrast, regulates almost entirely by enforcement, meaning it either brings actions against people or allows them to send in these no action letter requests to say, I want to do this thing. If I do this thing in the way I'm describing it to you, are you going to come after me, or are you not going to come after me? Right?
Which is a double-edged sword too, right? For industry participants, you're effectively put in the position of saying, especially where we are today with the regulation by enforcement, okay, I could ask for permission, but now I'm going to be on their radar. Yeah. Whereas maybe if I don't ask for permission, I'm not going to be on the radar, but I'm not 100% certain what we're doing is, comports with their perception of the law, because, one person could have a reasonable interpretation whether or not they are complying or they're not, right?
100%. And to make it even worse, right, as I learned myself, you can send in a no action letter request asking them to tell you whether or not you're allowed to do something, and there's no obligation to respond to you. They can just radio silence. They can, they can ghost you whenever they want to, right? There's absolutely nothing compelling the SEC to respond to your request to them to tell you whether or not you're allowed to do what you want to do. And so this actually gets at something really deep to me about the nature of the problem, and something that I noticed when I first started participating in the NFT market, and I found really interesting as a legal academic and someone interested in the kind of ontology or metaphysics, as it were, of securities, to see people talking about was, it was very, very common for people in the crypto world more broadly, but specifically in the NFT market that I was participating in, to be like, oh, what do I have to do? How do I have to structure my project? How do I have to describe what I'm doing in such a way as to make it not a security, right? And I just wanted to hold these people by the heads and be like, my friend, right? There is no magic words that you can use to make this not a security, because is it a security, at least under the law as it exists, is not an ontological question, right? There isn't a definition of the security other than whatever the SEC decides it wants to regulate, right? The decision of the SEC to regulate makes it a security. In kind of language theory terms, you could call it illocutionary, right? The same way that like a jury verdict makes somebody guilty or not guilty in the eyes of the law, the SEC's decision to regulate or not regulate makes something a security in the eyes of the law, right? And in fact, this idea that somehow magic words are going to change it is 100% or 180 degrees opposite to what was actually going on in Howey. And so, and this is something I really want to emphasize, I think this is important, right? People talk about the Howey test as if it's meaningful, but it's not, It's a totally empty set of words because it doesn't include or exclude any particular things, right? It's entirely discretionary on the part of the SEC. The important part of Howey isn't the Howey test, but rather the Supreme Court's observation that the definition of a security depends on the economic reality of the transaction, right? That for me is really the essence of Howey. And it should be obvious if you think about the factual context, right? After all, what happened in Howey? What was the case about, right? Well, there were people who owned a giant orange orchard in Florida, and they wanted to, in effect, accept investments in their orange orchard from regular investors, regular people out in the world, without going through SEC registration, right? So they came up with these fancy, complicated contracts where they described the investment as purchasing part of the orange orchard rather than investing in the entire orange orchard operation, even though the economic reality of what they were selling was actually an investment in the orange orchard. And so what the Supreme Court said was, look, you can't make it not a security by describing what you're doing in a fancy, convoluted way. We're going to look to the substance of what you're actually selling, right? Well, I mean, that for me is the answer to how, you ought to be thinking about this problem. What is the substance of the actual transaction, right? And then for me, the deeper question is, what is the SEC for? Right? What do we want the SEC to do? Why did we create the SEC? What's the institutional competence of the SEC? What's the nature of the market that the SEC was designed to regulate, and why? And what does that tell us about what the SEC should be regulating and what it shouldn't be regulating? And that also answers a lot of kind of really practical questions for me, right? Because the response to a lot of this is, well, if the SEC in particular, right? So the lawsuit that we're bringing is against the SEC for trying to regulate NFT sales, right? Which we explain is identical to the SEC regulating the art market. And the response from a lot of people is, well, if the SEC can't regulate this new market, it's going to be a disaster, right? Because slippery slope, right? People will describe what they're doing as selling art rather than as selling securities. And then, oh no, what a disaster. The SEC won't be able to regulate it because people cleverly described it in a misleading way that brought it outside of the SEC's jurisdiction. I'm like, that's just a bunch of hogwash, right? I mean, the art market existed before the SEC. The SEC has never regulated the art market, even though the economic reality of the art market has always been the same, right? When you invest in artwork, what you're always truly investing in is the commercial goodwill, the clout associated with an artist, right? So like what I like to say is, we think the art market is a market for objects, but it's not true, right? The object is just a physical token that represents an entry on a ledger, right? The catalog raisonné is what matters. It's the connection between the object and the catalog raisonné entry that establishes the authenticity of the object, right? The object is just a ticket. Without the catalog raisonné entry, it's just a dirty piece of canvas or a lumpy rock, right? It's not worth anything. The thing that makes it valuable in the art market is the ledger entry. The only thing different about the NFT market is we get rid of the physical object and let you transact directly in the ledger entry, right? Conceptual art got us most of the way there. The NFT market got us the whole way there. So in that respect, the art market has always been a securities market insofar as what you're doing is investing in the brand value of the artist, investing in the belief that the artist is going to grow their brand, so their brand is more valuable in the future, and therefore owning a share in the artist's career will be more valuable in the future as well. But the SEC has never regulated the art market, right? And it never conceptualized itself as regulating the art market. And you know what? It apparently wasn't hard for the SEC to distinguish between what's art and what's not art, right? It's been doing it for almost 100 years now. So I don't see the problem. I think it can keep doing it in the future.
Yeah, when I listen to you, And like I think about where the core angst and agita comes from in this space. Like to take it back to film, you mentioned 16 millimeter film. I graduated film school in 2008. We were the last to be shooting film. By 2010, the Steinbeck machines were gone. For anyone who wants to know those, it's like you physically cut the piece of film and tape it back together, like old school stuff. Now, we move forward. Everyone has a camera in their pocket, right? We can do, oh, amazing. I love it. Yes. So we've moved from this concept in filmmaking where you would record things on chemistry, chemical processes. We've gone so far ahead in time that every single person has a camera. We can do distribution. That's what technology is really covering with a simple push on TikTok. And suddenly you're not even just recording, you're distributing to the entire world. These were entire frameworks that just got rejiggered. Move forward to present day, we're making AI where you can't even tell what's real or not. Is it video? Is it not? Right? These are all things that we have to contend with. And I think blockchain has done a lot of this distribution sort of this leapfrogging that I described in video for the ability to raise capital. Not only can you now throw something out on the internet, but you can do the capital raises that used to be a very niche sector that existed within the financial sphere. And just like video now being on your cell phone and pushing out, it's no longer this esoteric niche. Anybody can do it. It's becoming broadly applicable. And then furthermore, beyond just raising the capital, you can distribute whatever that asset might be with the same greatest of ease. So I guess like my question to you is like our gripe is that the SEC is living in this like slower moving legal state, which is very much the past, while the technology is leapfrogging forward. And for us to overcome this, because it's like you're talking about, we want to keep producing and ideally producing assets with some utility. I would say your argument only validates the meme coin trend, which is like, let's wipe away any notion of there being true reality to this asset. And let's just trade names for what it's worth. Like very curious about how you feel about that.
Yeah, so there's a lot of really interesting questions packed in to what you just said. So I'll try to pick it apart a little bit at a time. I mean, to my mind, a big problem with the SEC in this moment is that it has settled into a kind of institutional inertia based on what it's used to regulating, right? So the SEC is used to big repeat players who it knows well coming back to it over and over and over again with a shared language and a shared understanding, right? They're not used to dealing with innovators. They're not used to dealing with outsiders. They're not used to dealing with people other than investment banks and Wall Street securities lawyers. And so I think for them, this looks like something unfamiliar, and agencies in general don't like unfamiliar things, especially really institutionally conservative agencies like the SEC. And I think as a consequence, their response to this is bad, and we want you to stop doing it, period. And I see Gary Gensler talking about the crypto industry, and my takeaway is Gary Gensler, if he could like wave his hand and make this all go away, that would be wonderful for him. He does not like any of this stuff happening at all. And I just think that that's a huge mistake. Like, I don't pretend to know the right answers, but when I see a market come into existence on its own, I see that as an example of latent demand, right, that needs to be sized. It's not like people had to be convinced to do this. People wanted this. It sprung into existence automatically, like organically. That is something that I think we need to pay attention to, because it tells us that there was an inefficiency that we weren't, that was impacting our ability to sort of engage in transactions that could be mutually beneficial for everyone, right? So I hear a lot of, returning to the NFT market, right? There are always people like, well, you can do all that stuff without NFTs. All the NFTs do is like reduce transactions costs. I'm like, oh, all they do is reduce transactions costs. Geez, what a drag, right? Who would have thought that, I wish they could do something more valuable than reduce transactions costs. I'm like, come on, guys. Like, this is the stupidest argument I've ever heard, right? I mean, reducing transactions costs is everything, right? I mean, it shows us possibilities that previously had been inconceivable. And I think back to when I was, a young 20-something art student, right, looking at the film art world and being like, geez, filmmakers seem not to be able to make money in the art market the way that other artists can. How can we fix that so that filmmakers can sell themselves the same way that other artists can? And the response from everyone was, well, that's impossible. You can't do that. That'll never happen. That's a stupid idea. What are you talking about? And I was like, no. I'm like, there's a market there. It's just some people can participate in it and other people can't, right? And the assumption was like, well, this is a copyright market, right? This is about controlling access. It's about controlling use, about selling copies. It's about scarcity, not about abundance, right? But technology changed all that, right? I mean, it used to be copyright was a great policy tool for solving market failures in works of authorship, right? Because it was expensive to make copies and it was expensive to distribute copies, right? But now it's free to make copies and it's free to distribute copies. Copyright doesn't solve market failures anymore. Copyright is the market failure, right? Copyright only makes things more expensive and more complicated when what we should be living in is a world of abundance. And to my mind, right, what was exciting about the NFT market was I would say, wait a minute, right? This is a market, right, tailor-made for that particular kind of abundance, right? Because the only thing that it needs to be scarce is clout, right? That's the only thing you have to be buying and selling. The work itself, you can distribute to as many people as you want to. And in fact, right, the market encourages you to distribute it to as many people as possible, because the more people who consume the artwork, the more clout you have and the more valuable your brand becomes and the more you can sell. So I see this as like in a really interesting way, effectively giving creators access to the capital markets that they've never had before, right? And an ability to realize the social value that they're actually bringing to the table. And to bring that back to the SEC, right? I mean, is what I'm describing as securities market there? Well, in some really abstract sense, yes, you're selling securitized shares in your clout. I think the deeper point here, though, is that the SEC, at least to my knowledge, has nothing to add to regulating that, right? I mean, like, people think about it this way, right? People are talking about, oh, well, Bored Ape Yacht Club, these NFT are selling for so much money, right? Surely there's a securities market problem here. Surely the SEC should step in and do something about it. I'm like, well, wait a minute. Like, let's do nuts and bolts here, right? If the SEC is going to regulate Bored Ape Yacht Club, what is it going to do exactly, right? Tell people we want to make a disclosure that what you are purchasing is a digital ticket that represents nominal ownership of a picture of a monkey. Okay, thanks. I mean, everyone knew that already, right? That's not a useful role for the SEC to play. Now, is it possible that there are things the SEC could do in this space that would in fact be good and valuable? Probably, right? And honestly, if the SEC wants to like set up a conceptual art division, like count me in, man. I'm happy to participate in that. They don't seem interested in my help. But maybe there's a role for a regulator in this space. I'm totally agnostic on that front. But I think that in order to play that role, the agency has to take a long, hard look at its own competence, at the nature of the market. It has to understand the market it's regulating. It has to understand what problems, if any, there are in the market. And it has to ask itself, what can we do, if anything, that will make this market better, right? What will make it a stronger market? What will actually protect consumers as opposed to just creating more inefficiencies and costs, right? And I think, to bring it back around, right? I think the big problem from my perspective is the SEC is fundamentally incapable of conceptualizing itself in that way. It has no institutional capacity to think about the future, right? It has no institutional capacity to think about change, right? It has no institutional capacity to think about why it's doing what it's doing. I find that really disappointing.
I think you really hit on a good point, which is that the SEC serves a role right, in the marketplace, and it's not just investor protection. Their role is to enable these markets to develop in a way that is conducive for businesses to raise capital, but also for our economy to function. So a lot of what I think we've seen is maybe not speaking for the SEC, obviously I have no affiliation, but they probably are under pressure or were under pressure to do something. Because remember too, when something goes wrong, people are looking and saying, where were you? So like they have to do something. They can't just not do anything. And I don't think to your point, they actually understand the technology enough, both FINRA, SEC and FINRA, by the way, understand the technology enough and what it is to take a step back and say, okay, like let's not just like start like shooting all of these different companies like this. Why don't we actually think about what we want this to look like in the next 100 years? Like, where do we see this actually developing? Where do the digital asset market in the United States, where does this all go from here? So maybe they were put in the position that they just had to do something quickly, especially after FTX and everything like that. There's also obviously like political agendas of certain people and stuff like that. But I think you hit a good point of like there is a role for often these regulators, and it's not just to investors; it's actually to businesses as well.
Yeah, yeah, no, I think there's a lot of truth to that. I really do, and I think that kind of it's a helpful frame for understanding what we're doing and why we're doing it, right? Because essentially what happened was, from 2021 onward, right? Or really even slightly before then, I've been kind of out there being like, hey, by the way, right? I mean, all of this is unregistered securities if the SEC wants it to be. And you should really think about that and think about engaging and think about differentiating in a meaningful and helpful way, as opposed to kind of magic hand waving way, which is never going to work, right? And for a long time, I think a lot of people were like, yeah, whatever, right? The SEC is never going to do this kind of stuff. This isn't something that they care about. You have nothing to worry about, et cetera, right? But it really came to a head with the Stoner Cats settlement from a little while back, because that was essentially a very bog standard NFT project, right? They said, hey, we want to create this animated cartoon thing, and we're going to sell NFTs to fund the production costs. And, if it's successful and popular, maybe the value of the NFTs will go up and you'll make money, right? And, they made a lot of like to do about how cool it was going to be and how, the NFT is going to be great in the future and whatever. But like literally every artist ever does that, right? You're not going to walk into an art gallery and have the artist be like, yeah, I did these paintings, you should buy one. Maybe it'll be valuable later, maybe it won't. Who knows? Kind of depends on whether or not people like my work, right? And of course, you can sell yourself. I mean, it's like, no one's put a disclaimer on the painting saying I'm selling it for 20 grand, but it could very well be worth nothing in the future. You never know, right? So I mean, like a very bog standard NFT project, right? The SEC didn't explain in any way how this project was different from any other project. And there were two commissioners being like, what the hell are we doing, right? This makes no sense. Like on this theory that we're advancing in this settlement order, right? Every NFT, the entire art market, and most collectible markets too, are all securities markets that have to be registered with the SEC. That just doesn't make any sense. So that's what got Jonathan Mann, my co-plaintiff, worked up, right? Because he was like, wait a minute, I'm selling NFTs in my songs, right? That's exactly the same as Stoner Cats, right? The promise of buying an NFT in my song is I'm going to be more popular in the future than I am today, and therefore the value of owning the NFT in my song is going to be higher in the future than it is now, right? And so, he hooked up with Jason over that kind of concern observation, like, what do we do about this? And then they were kind of asking, well, who would be another good plaintiff? You always have more than one plaintiff, right? Just in case. And I was kind of the obvious answer to that question, right? To like, well, a yin yang kind of deal, as it were, right? I mean, it's like I'm doing something a little different, but I think complementary in a lot of ways to to what Jonathan is doing. So I mean, like for me, I agree, and part of what we're trying to do is to kind of bring the SEC back to the table, right? I think, and say, hey, wait a minute, like maybe you should think a little bit harder about these decisions you're making about what to regulate and how to regulate, because, you know, as you say, they seem to have acted a little off the cuff here. And I think that was probably a mistake. And I think that was partially a function of how the SEC operates, right? I mean, they were able to pick their defendant, right? And they looked around till they found a defendant that had, you know, said some unfortunate things, although they weren't really material to what they were doing, and a defendant that wasn't going to defend itself because it was already, the project was already done, and the NFT market had already tanked, right? So like, no sense throwing good money after bad, defending your right to do something when there's no money left in it, right? So they, of course, settled, because why wouldn't you, like, rather than spend all the money on lawyers to prosecute a case against the SEC you may or may not win, right? Now we're coming to them, and it's a very different situation, right? And we're not the defendants that I think the SEC would choose in this kind of an action. So I'm very interested to see how they respond to our lawsuit, because I can anticipate what their procedural responses are likely to be, but I think responding on the merits is going to be very uncomfortable.
Yeah, I enjoy your colorful term of saying that you're trolling them, but like, given this conversation, let's say I do want to launch an NFT project. Let's say I'm an up and coming issuer. I'm sorry, artist. Is there even an option, right? Like, is this path really the path that you would have to consider if you were going to move forward on one of these, let's call them a project?
Well, I mean, in theory, after Stoner Cats, essentially any NFT project is at least potentially an unregistered security, if the SEC wants it to be, right? Now, if you're considering launching an NFT project right now, setting aside the fact that it's pretty hard to sell an NFT project at the moment, although, you know, fingers crossed in the future, the market will rebound and people will realize that this is actually a really sensible way of funding the creative industries. In my opinion, right? I think that the future of NFTs or something like them, in my opinion, is bright. I think it's just going to take people a while to really get there and realize how they are, what they are, and how they work. But as a practical matter, I think that given our pending lawsuit, I suspect the SEC would be very reluctant to start bringing more enforcement actions at this particular moment, because that would probably not be great for their litigation strategy, right? I mean, I suspect, here I'm just spitballing, right? But I suspect that they're going to say something along the lines of, well, that's not the kind of thing we would regulate in the first place, right? So if they're bringing more enforcement actions, I think it'd be pretty hard for them to make that argument. And it sounds kind of like we're just going to dodge the cases we don't like and bring actions against the ones where the defendants look to be in a weak position. I suspect courts would find that not compelling.
Fair. And like, I guess, you know, it's an interesting term to call them unregistered securities, right? Because if registration is not an option, and you can go through Reg S, Reg D, like, you know, where are we? This is really the core of the issue, right? It's just that it's all fully opaque. And registered versus unregistered, I'm not sure I get the difference.
Yeah, no, I mean, that's a fair point, right? I mean, you know, it's the technical term, although you're right that the SEC can make things unregistered simply by refusing to register them. Like, we're just not going to include this in the basket. We're just going to tell you you're not allowed to do it. You know, I think there's an open question. I mean, there's a political element to it, I think, where on one level, I think The SEC, like I said, like they're very resistant to change, and they don't want to see this new stuff that they don't understand happening, at least until they feel comfortable and like they understand it. And who knows how long how long that would take to happen if it ever does. But if there's enough people saying, hey, you can't just like punt on this, you need to do something, which seems to be happening to some degree, right? I mean, I think that they at some point feel institutional pressure to start engaging, or at least not prohibiting. And I kind of feel like in a lot of ways, the place that they've fallen, frankly, is just to see no evil, hear no evil, right? Which, I mean, again, that's disappointing to me. Like, that's not an okay response, right? The response should not be, if you come to us and try to work with us, we're gonna smack you down and punish you. But if you just ignore us, we're gonna pretend like it's not happening until it blows up, and then we don't have a choice. That's just, I mean, I'm sorry, but that just seems really irresponsible to me. You know, I felt like I feel like a Jewish mother. You know, I'm like,
Well, if you want to protect the investors, like we're talking, when they say they come after you, it's the issuer, but the investors get burnt by that too, right? So it becomes this circle of head scratching where you're like, hey, there's all these average people. I think the ICO era brought a lot of us into the awareness of accredited investors, which, nobody had understood that before because we were all broke, independents. But yeah, it's like that's the pain, is that you're actually hurting the average person who tossed a couple bucks into this thing, and that's just something that is a very confusing sort of.
and I want to be clear again. Like, I'm not opposed to regulation, right? In fact, I'm in favor of regulation. In fact, I think a lot of people in the crypto industry and even in the NFT market are on some level in favor of regulation, or at least open to the concept of regulation, so long as it makes sense or is even just available to them as an option, right?
Right.
My only point is that, if you're going to regulate, I think it's really incumbent upon the regulator to think long and hard about what they're trying to accomplish and whether what they're proposing to do is likely or unlikely to achieve that goal. And I'm like, and I don't think that's asking that much. I mean, really, I think that's a pretty small ask. Like, you don't have to be right, but you at least have to think about it and try.
When we're talking about the unregistered, right, registration, there is that middle ground, like we were discussing, of exemptions from registration. So I think a lot of the projects that we've seen historically that go down the path of registration, which is, even leveraging like Reg A, which is an exemption, but still you have to interact with the SEC. A lot of those projects ultimately end up in this graveyard, right? The cost of counsel, on top of that, just a back and forth with regulators who rather just keep kicking the can as long as they can till you run out of money. It kind of seems like that if you look back at what's happened. But there has to be this middle ground, and then there's also this question of, well, if you do an exempt offering, for example, like a Reg D or Reg S or something like that, and there's the actual the instrument itself, call it like a token purchase agreement. What is the ultimate thing that's produced from that? Is the security the agreement itself? Is the security the token that ultimately may be minted in the future but may not be minted in the future? Like, these are questions that there's, we have general positions on them that, we don't need to go to right now, but it's just like we need some clarity. Tell us what to. I think it comes down to this: if you tell us what to do, you will have a lot of people going and doing that, especially on the legal side. Lawyers are just sitting there like, please tell us, like, please tell us what we should do so we could tell our clients. So when we tell them, well, it depends, and then they get mad at us, we have like some reasonable position that we could give them. But at the end of the day, the industry is not going away. It's growing exponentially. We're going to need some clarity. And, these one-off enforcement actions are insufficient to give us the clarity that we need. And also, Graham, to your point, we're just setting up a position where we're going back where, like, venture capitalists and those large institutions are being able to participate in these early token offerings, and then you're excluding retail investors when the whole point of all of this is to engage with people and to give investors, everyday people, my mom, the opportunity to maybe invest in something she's excited about and then, see that thing grow, not have institutions come in, buy huge, blocks of this and then dump it on some secondaries exchange that no one's looking at, somewhere in the world. So we're not in a good place right now in terms of like, it's not helping regular people. It's not giving clarity to companies. And we just all, I think, as an industry need to move better, need to do better, and regulators here also.
Yeah, no, I think that's 100% right. And I think on some level, for me, it actually reflects on some level the empty formalism of the way that the SEC approaches regulation, right? So it's focusing on the how we test rather than on the how we substance, right? And so, Mara, you asked like, well, where is the security? What is the security, right? I think the problem is you can't answer that question with a test, right? You have to look to the nature of the transaction itself and ask, what is it? What's happening? And why or why not should it be the subject of regulation? But I mean, it's not on you, or it shouldn't, in my opinion, be on you or on your clients, right? The people who are trying to do the transactions to conceptualize what's happening. That's the SEC's job, right? They need to wrap their heads around that. They need to decide what they think the point of regulating is, right? They need to decide what kinds of transactions fall within the basket that they think represents the economic reality of the securities market. And they can't just keep like using the Howey test as a crutch and saying, oh, well, this answers all your questions, because it doesn't answer anything, right? It's empty. It's totally empty, right? And I, again, I just find that really disappointing, right? Because you shouldn't have to guess what the SEC is going to do. You shouldn't have to guess how the SEC conceptualizes what it's regulating and why it's regulating it. The SEC should be telling you that. And that, that could come in the form of like really explicit rules, do this or do that, right? But honestly, like, I feel like the SEC could also like maybe take a step back from that and just talk about these questions more theoretically, right? And say, this is our policy choice and what we want to accomplish. And you should take these theories of the securities market into account when structuring transactions in order to understand, because like people in finance are plenty good at thinking theoretically. And if you tell them what the theories are, right, they can use that. That's helpful. But you got to get there. As an agency, I don't think they're there.
We can literally program the rules into the new financial rails. So give us something and they will appear.
That's right. That's right. But my sense is that the SEC doesn't want to do that because they're worried that if they do rules, then people will like engage in shenanigans to like technically satisfy the rules, but violate the spirit of the rules.
So instead, they're not making it, right? Like,
but I mean, like this is a constant law student problem.
Right.
Right. It's like there's this, there's this joke, right? That, students go to law school because they don't want to have to do math. But my response to that is the irony is that every single law student wants the law to be math, right? They want to know what the rule is. They want to be able to like plug the facts into the rule so it spits out the right answer and they get an A on their exam. And I'm like, my dudes, you knew it wasn't math when you came here, right? And it can't be math. And I feel like what the SEC wants is or what they're worried about is like, oh, well, if we are, if we say too much or we tell people too much or we give too much guidance, it'll be like math and people will be able to like evade the rules. I'm like, no. You can promulgate abstract conceptual rules too, right? And I think about this as like, so as a copyright law professor and copyright lawyer, right? I encounter this problem all the time, right? Because one of the big issues in copyright law is fair use. right? It's technically an exception to copyright protection, but it's like, those 4 fair use factors you're supposed to consider in determining whether or not any particular use of a copyrighted use is or isn't fair. And what I always tell my students are like, oh, 4 fair use factors. And of course, they march through the factors, blah, blah, blah. And I'm like, look, guys, the fair use factors aren't telling the courts or aren't how the courts determine what the outcome is going to be. The 4 fair use factors, 4 factors once again, right? Just like the Howey test, the 4 fair use factors are how the court explains why it reached the outcome, right? So if you're arguing the factors, you're losing, because fair use is always a policy question, right? And what you should be arguing is why it would be good or bad policy for this particular use to be fair or not. And I think, frankly, the same thing ought to be applying in the securities context, right? Why would it be good or bad policy to regulate or not regulate in any particular way this particular kind of transaction, right? And will you always know in advance? Will that provide you a perfect rule so you can always predict? No, but you know what? So what? That's not how the world works. Right? Sometimes there's a little bit of uncertainty, but a little bit of uncertainty is better than total uncertainty.
Yep. Well, luckily for us, the bull case is that every day a new child is born into a world where blockchain has existed for over 13 years. And I am highly confident that they will open a Web3 wallet long before they get into anything else, being financial related or regulations. So in a war of attrition, we've got pretty good odds. And, I just want to thank you for actually stepping up there and taking that first step to kind of be on the offense, because it does seem right now offense is going to be our best defense.
Thanks. Yeah, it's an honor and a privilege to be out on the front lines asking questions that the SEC doesn't want to answer.
Amazing. I'm gonna sort of wrap it up, I guess, for sake of time. But I want to pass it to Mario if there's any final question. And then my last thing I would like to go out on is just like, is there anything that the people can do to support this?
Yeah, I'd love to know like how you're thinking about the potential impact of what you're doing here, right? When you think about when you made the decision, I'm gonna sue the SEC. Right, that is not a little decision. That is major, right? If you're sitting anywhere and you're plaintiff in an action like that, you could just suspect the global eyes are on you for those people who are in the industry, especially in the legal side of things. So where do you think what would you call a win here at the end of the day? And what would you want to see kind of be the ultimate result of these efforts that you're participating in here?
Yeah, no, 100%. I mean, so this is my first time ever being a plaintiff, or really even a plaintiff's lawyer. I've always been on the defense side of things. So it's definitely a new experience for me. Although from my perspective, it was a really easy choice, right? When Jonathan and Jason came to me and asked if I was interested, I mean, this was like the culmination of a multi-year project for me. So I couldn't be more excited about this project, in large part because I'm just really interested to see what happens and how the SEC responds to what we've done. I think there's a lot of potential responses, and I'm honestly not sure what I think is going to happen, right? I mean, one possibility is that the SEC just files an answer, right, and says, we're going to litigate this, and we think we can't regulate what you're proposing to do. I mean, after all, the project I'm proposing is titled Cryptographic Tokens of Material Financial Benefit, and it's an exact copy of Stoner Cats, basically, with nothing attached to it other than I describe it as I'm selling you the feeling of being a winner.
If that doesn't do it, I don't know what will.
I stole that from Steve Pikelny. But yeah. So on one level, they could just say we're going to respond on the merits and we're going to proceed against this, and I would love to see how a court reacts to that, because I think the SEC is going to find it really, really difficult to distinguish what Jonathan and I are doing from selling our work in the art market. And if they can't make that distinction, I think courts are going to be really hard pressed to find in their favor, because I don't think the courts or the SEC, frankly, think that they have the authority or the mandate to regulate the art market. And that just can't be right. And we say that over and over again in the complaint. I think the much more likely response is that the SEC is eventually gonna file a motion to dismiss, probably primarily jurisdictional. I think they're going to argue lack of standing because, like, well, we wouldn't actually, we have no intention of actually pursuing an action against you. Therefore, there's no basis for a declaratory judgment action. The problem there is, I've filed 2 no action letter requests already that they haven't responded to. And the project I'm proposing is identical to one that they brought an action against in all material respects. So I think that's going to be a tough argument for them to sell to the court as well, unless they admit that Stoner Cats was just wrong, right? And that they should not have brought that action in the first place, which, 2 of the commissioners already think so. So you never know, right? Maybe the SEC does an about face on that front. They may also file a motion to dismiss for failure to state a claim. I think that's going to be an even tougher one than filing a procedural motion. I just don't see how they're going to do that. And then I guess the third option is they could just give up, right? And say, no, you're right. You're allowed to do that. And that's not something that we can regulate. It's possible. It would be easy. I don't know for sure. I think that would be an interesting win, and even more interesting, like, whether the SEC agrees to that initially or whether we ultimately reach that outcome. I think it will be interesting to see how the SEC conceptualizes its role in this market and the nature of its regulatory authority in relation to this market differently as a consequence of what has happened. Because to my mind, like, the reason I started pursuing this project in the first place, right? The reason I wrote these papers, the reason I've been harping on this over and over again is, frankly, I think that at its heart, this is a really existential question for the SEC that they don't want to ask themselves. What are we for? What is a security, right? What are we supposed to be doing as an agency? I think that's a hard question for a regulator to ask, and I think it's an especially hard question for the SEC to ask. I kind of wish William O. Douglas were still here, because I feel like he's a lot more suited to answer those kind of questions than Gary Gensler is.
We'll see, though. There's likely gonna be a shift in the administration, right? So I'm actually really curious too, like, how that impacts specifically your lawsuit as well. And maybe
if they make Hester Pierce the new commissioner, that could be very good for us. But yeah, so I think there's a lot of open questions. We're not likely to hear anything from the SEC for a while yet. They've got something like 60 days to file a response, and I think they're going to get an extension, which is pretty common. So likely nothing till the end of the year sometime. So we'll see what happens on that front. And in the meantime, you asked what people can do. From my perspective, the most important and most valuable and most gratifying thing that people can do is just talk about it, right? Get the word out, encourage people to kind of dig deeper into what the lawsuit is about, read the complaint, right? Which I think, Jason did an amazing job writing the complaint. And I think it's really powerful, punchy, and makes a lot of really important points. And, get it out there into the kind of mainstream discourse, because, I think at this point, a lot of people don't yet fully understand what the lawsuit is about and why we're bringing it in the first place, and that it's not really just about NFTs or just about crypto, but I think it's a much deeper question about the nature of the SEC.
Yeah, I would encourage the listeners as well to read the complaint. It's very well drafted and written in a way that's like good legal writing, narrative format. So it's not, boring. It's not, just coming from a lawyer, but very well drafted, and actually lays out a lot of this that we talked about, that like there's very, little clarity, and just if you could guide us in the right direction. But handing it back to you, Graham, to close out.
Oh, and by the way, if people are interested in the stuff that I've written in this area, everything I've done is available on my SSRN page or, via Google, whatever. But my work is all free. You can download it, and it's also plagiarism encouraged. So if you want to take my ideas and make them your own, you're not only allowed to, but I encourage you to do so.
Yeah, we'll definitely add links to all of that content, as well as Jonathan's song if you prefer your legalese in musical format of This Song is a Security. It's pretty awesome. And I guess until then, I'll just, I see your vinyl, I'll play the role of Tommy and just say, see me, feel me, touch me, feel me, in hopes that they can get on board with that message. But thank you so much for your time. This was like a truly amazing conversation. I think we'd like to have you back later on to maybe get a follow-up when some stuff plays out. But up until then, just again, thanks so much, and we look forward to watching this unravel.
Awesome. Nice to meet you. I'd love to. My pleasure.
Take care, Brian.
Perfect.
Bye-bye.
Thank you. Right.